All right, thanks, Phil. Hi, everybody. Thanks for having me back again. We're going to feel a little bit of deja vu, as I was when I was reviewing my slides, because I thought, didn't we talk about this stuff last year and the year before and the year before and the year before? And we did, but we've got some closure on some things we're going to be able to talk about this year, which is kind of nice and kind of different. So I will do my best to make it through all of my slides before Phil tries to pull the plug on me for questions. And as I think he'll note at the end, if anyone has follow-up questions as to things we don't get to, I have my email at the end of the presentation and happy to speak with any of you after. So to begin, I am required as an attorney with my ethical obligations to state that this presentation is for informational purposes only. It is not legal advice. There you go. So what are we going to talk about today? Well, we're going to, as we always do, even though I know most of you know this stuff probably inside and out by now, we're going to just do a very brief legal overview, state of the law, the basis of the body of law surrounding website accessibility for folks who might be new to it. We won't prolong it for those of you who are experts in it. But we will level set. You all know what an accessible website is, but again, just sort of a quick level set there as well. We have our 2022 year wrap up data that we will talk about. We'll talk about some key lawsuits and settlements. And then if we have time, we'll talk about strategies for avoiding and defending legal actions and the typical roadmap to accessibility. I know y'all know that stuff pretty well as well, but there's some takeaways from some of the cases that we always like to remind folks of. Starting with our legal overview. Now, I am an attorney licensed in California, practice in the United States. So we're only talking about US laws here. We know that there are various laws and guidance around the world that may require accessible technologies as well. We're focused on US laws here today, that we've got various federal laws, and we have various federal regulations, and then we have some state laws as well. On this slide, you can see the federal laws. When we're talking about Title II of the ADA, we're talking about the law that applies to state and local governmental entities. Title III of the ADA, we're essentially talking about private businesses, or the term of art is public accommodations. That's important, and as you'll hear as we go on. Other places where web and other mobile apps, other types of accessible technologies might come up, Section 504 of the Rehabilitation Act, and even more specifically, Section 508 of the Rehabilitation Act, which talks about the technical aspects of things. And again, I mentioned state non-discrimination laws. California, New York are two that actually allow for recovery of monetary compensation, damages or penalties, in addition to attorney's fees and costs. Air Carrier Access Act and the Affordable Care Act and Medicare regulations. That is your high-level overview. What does the ADA require? And again, we're going to talk about Title III of the ADA primarily today, since that is where all the litigation is occurring. The vast majority, vast majority, I shouldn't say all of it, but the vast majority of litigation is occurring. So as y'all know, the ADA is a federal civil rights law that prohibits discrimination against individuals with disabilities, signed into law in 1990. 5 areas are covered by the ADA. Title I, employment. It applies to employer-employee relationships. Title II, like I said a minute ago, state and local governments. Title II also public transportation, although that doesn't come up nearly as often for us. Title III, essentially private businesses, and then Title IV, telecom, and we won't talk about that today. We're going to focus on Title III. So under Title III of the ADA, places of public accommodation must, these are the main components of the law, have facilities that are accessible and maintain accessible facilities to individuals with disabilities. Again, this applies to members of the public. If we're talking about employees, we're talking about Title Public accommodations must also make reasonable modifications to policies, practices, and procedures when necessary to ensure equal access to individuals with disabilities and ensure effective communication with individuals with disabilities by providing auxiliary aids and services at no additional charge. One possible auxiliary aid and service that might need to be provided is accessible electronic information technology. This all seems super fundamental, right? And some of it seems not relevant to our digital accessibility update today, but it is relevant because it's this effective communication obligation, as well as the fundamental equal access principle of the ADA that is the basis for all of the lawsuits and actions that we see here. What are the remedies? If a defendant is found to have violated Title III of the ADA, a private party can file a lawsuit, doesn't have to exhaust administrative remedy or file, a complaint with the DOJ first, although you can file a complaint with the DOJ, but you can also file directly in court. And if you win, you can get an order from the court that the website needs to be remediated, needs to be made accessible, for example. That's the injunctive relief portion, and attorney's fees and costs. If you also make a claim or only make a claim, for example, for a violation of a state law like California's UNRRA Act or any of the New York state or city laws requiring accessibility, you might also be able to recover damages or penalties as well. If the DOJ pursues an action for violation of Title III of the ADA, the current financial basis for penalties, this is in a table in the Federal Register that changes just about every year, but as of January 30th, 2023, the penalties are a maximum of $100,000, $111,000, and $614,000 for a first violation, and $223,000 and $229 for a subsequent violation. I sure hope I said those right. Essentially, $111,000 for a first violation and about $220,000 for a second violation. Also, injunctive relief, damages, injunctive relief again, and more damages. Apparently, apologies for the typo on that last slide. Okay, so what is a place of public accommodation? Again, this is super fundamental. On this slide, we have listed the 12 categories of place of public accommodation that are set forth in the law. We're not going to talk about them, but I have them on the slide here because if the business that is being sued, for example, has to fit within one of these 12 categories to actually have a valid claim asserted against it. And a business can even have different characters essentially based on whatever service it might be providing or the capacity in which it's getting sued. For example, there was a case this year that came out where it was a law firm, and a law firm could potentially be a place of public accommodation, but if the capacity in which someone is suing it or the alleged violation is something that doesn't have anything to do with goods or services being offered to the general public, then that quite likely might not fit it into one of these 12 categories of place of public accommodation and not subject it to Title III of the ADA. We have seen courts sometimes shoehorn businesses into these 12 categories, even if the pure service being provided or the characterization at the time would not seem to lend itself to this. So, one would be cautioned to ever really hang their hat on, I don't strictly fall within any of these 12 categories without really analyzing it. The main reason why I have this slide up is because the term of art in Title III of the ADA is place of public accommodation. And so a lot of courts have been focusing most of their time over the last year plus, especially over last year, deciding the question of whether to be subject to Title III of the ADA, a business must have an actual physical place, or whether a web-only business can be subject to Title III of the ADA. And those cases have all come from this plain statutory language of Title III of place of public accommodation. As you can see at the very bottom of the slide here, or read at the bottom of the slide, the 9th, 11th, and 3rd circuits essentially say, yes, there has to be a nexus, meaning there has to be some sort of physical place of business for a website to be subject to Title III of the ADA. The First Circuit essentially says no, and then we have a lot of courts, not on the appellate level within the circuits, that differ as well, and some circuit courts that haven't decided the issue. Also, we'll talk about that in a bit. What is an accessible website? As you all know, it is one that can be used by people with various types of disabilities. We have blind up here at the top because the vast majority of lawsuits we see are by people who are blind. And the most common barriers that we see in these lawsuits are lacking alternative text, form fields that are not properly labeled, improper use of headings, and the keyboard only capability not being properly configured. And then while we don't see as many, up here we also have potential audio descriptions for videos as being a means or another aspect of a website that would need to be present for full accessibility. We don't see that very much in lawsuits, but what we do see is we see closed captioning cases for people with hearing related disabilities coming up more and more, but still not nearly in the quantity that we see cases being brought with various types of barriers to plaintiffs who are blind. Note that it's very rare that we see people who have other types of vision related disabilities bringing lawsuits. The vast majority are people who allege that they are blind and use a screen reader to access the website. You all know about the Web Content Accessibility Guidelines. And the most important thing from this slide is that it is not a legal standard under Title III of the ADA at this time. Okay, so why don't we have, and in these presentations, I usually hammer over and over and over and over that Title III of the ADA does not set a standard that websites must meet to be considered compliant with the ADA, or for the business to be considered compliant with the ADA with respect to the website. And yeah, I'll probably continue to hammer it, but the best way to talk about it is to talk about, well, why is there a standard? Well, first of all, like I said, the ADA was enacted in 1990. And here's my joke that I'm probably aging out of at this point. The internet was not even glimmer and Al Gore's eye at that time. So of course, the drafters of the ADA didn't think to include websites as they were drafting the ADA. But since then, we have had efforts to enact regulations that would provide guidance to businesses, and perhaps even set a standard for how a website must be coded to be compliant with the ADA. This slide you've all seen before. It's just a walk down memory lane. We did have the first advanced notice of proposed rulemaking out of the DOJ regarding website regulations that was pending from 2010 to 2016. And there was public comment on various questions
Stand by. We'll see if we can get Kristina back.
Okay, that was fun. Is everyone back? Okay, we're gonna try again. Apparently Zoom decided to crash on me. That's a first. Okay, so let me get my slides going again for you all. Oh boy.
That was a quick comeback, no harm.
Yeah, except now I'm stalling here, getting my slides going again. Talk amongst yourselves, think about your questions. My slideshow does not want to cooperate. Okay, closing it out, reopening it. If there's anything you all are dying to hear about, you can start sending those questions to Phil as we're pulling this back up here. And y'all will get these slides. So I promise I won't try to speed up talking too much, but I may skip over some stuff. Okay.
Yeah, I'm seeing some great questions. So now's a good time to type some in. If Kristina does not get to your question, then all the better. At the end, we'll raise them.
Okay. All my PowerPoint is not cooperating on my screen. So y'all are going to get the view where you get to see a slide ahead so that we don't slow down too much. Okay. So we were talking about DOJ during the post-Obama, pre-Biden era. And okay, so with that, we didn't have a whole lot going on. And we're just going to skip over the rest of what happened during that era because I think we all wish it didn't happen anyway. So we then bring ourselves to last year. And what happened last year? We've got Joe Biden as our president again. We have a new administration in the DOJ. And we saw some action restarting again. And on my slide here is entitled DOJ position and in parentheses in action over the years. We saw action starting in 2022. So the first event was in February 2022. Some advocacy groups published a joint letter to enforce accessibility standards to the head at the relevant head at DOJ, asking DOJ to adopt enforceable online accessibility standards by the end of the current administration. Which we knew could be 4 years, could be 8 years, but still, you know, faster than we got things done during the Obama administration on this front. Then in March 2022, the DOJ issued a guidance regarding website accessibility, which was great because it was an official publication from the DOJ that had the DOJ's position on various points regarding website accessibility, but it didn't really say anything we didn't already know from things that DOJ had put out before. And many thought, oh, okay, well, the DOJ's issued guidance, so that means this is all you're going to get. We're going to issue this because we're not going to do regulations. Then June 22nd, 2022, 12 senators sent a letter to the DOJ saying that it is critical that the DOJ restart rulemaking. So then soon after that, July 2022, the DOJ announced its intent to begin the rulemaking process to enact website accessibility regulations for state and local governments under Title II of the ADA. Now, remember before I said Title II is state and local governments. So, that's not going to do a whole lot with respect to the large amounts of litigation we see with respect to private businesses. But it is very much expected that any action that is taken with respect to Title II would be the precursor to action under Title III, which does apply to private businesses, and that they will follow very similar form. So it's really important that for anyone who has an interest in regulations under Title III, pay very close attention to the Title II rulemaking process and submit comments in the comment period. So the timeline that the DOJ announced in July 2022 was that by April 2023, next month, the DOJ would issue a notice of proposed rulemaking. And then by June 2023, public comment should be due to the DOJ. So we'll be watching very carefully in April to see if that notice of proposed rulemaking does issue. And then we're off to the hopefully not turtle races like we were last time around at that time. Also in 2022, we saw kind of a big action come out of the DOJ. It announced that it had entered into a consent decree with UC Berkeley, regarding the captioning of online video content, but also more broad aspects of accessibility as well. And that was one of the first big things on this front we've seen out of the DOJ for a while. And this year, in February, the DOJ released its first report on the federal government's compliance with Section 508 of the Rehabilitation Act in 10 years. And that report showed that many agencies were not complying with 508's web accessibility mandate, showing, not only do we, need some sort of guidance to businesses, but also, if a lot of the agencies aren't complying with a law that already requires website accessibility, a lot of guidance and who knows what else is really probably needed to move the accessibility, move accessibility along. All right, let's get into our statistics. So we're talking about ADA Title III lawsuit numbers on all bases. So this graph talks about not just website accessibility lawsuits, but lawsuits on all bases under Title III of the ADA: service animals, physical accessibility, reasonable accommodations, other types of effective communication. So as you know, if you read our blog, we post these statistics every year, and we have seen year over year a consistent increase. Well, in 2022, it was the first time we saw a decrease, really. I mean, we saw a 1% decrease in 2019 from 2018, but we saw a 24% increase this year from 2021, which is a big drop. There are a couple potential reasons for that drop. One being that one of the most prolific filers of website accessibility lawsuits, a law firm in California, was having some difficulties with various district attorneys in California that probably slowed down the number of filings it was making. And in case you're curious, the last 2 years of numbers, we were at 11,500 in 2020 lawsuits filed in federal courts only. This is not state courts, and this is not demand letters that may have issued and never showed up as an actual lawsuit, because we obviously can't collect data on that, and it is a lot harder to collect data on state court lawsuits than federal court lawsuits. So we had 11,500 lawsuits in 2021, and we had 8,600 lawsuits in 2022. Next, we are talking about the top 10 states for all lawsuit filings. And New York led the charge in 2022 with 3,100 lawsuits. California was second with 2,500. Florida first with 1,300, followed by Texas, Pennsylvania, Tennessee, Missouri, Georgia, with decreasing numbers in the low hundreds there. You'll see why this is relevant in a minute. When we are looking at the numbers of those big three, California, New York, and Florida, it is interesting because when we started tracking these lawsuits in 2013, we had, let's see, California had 995 accessibility lawsuits, Florida had 816, and New York had 125. Fast forward to 2021, California had almost 6,000 lawsuits. New York had almost 2,800 lawsuits, and Florida had just over 1,000. Florida's actually hover plus or minus 1,000 pretty much every year throughout the years. Where you've seen the big differences are California going up to a peak in 2021, and New York staying pretty steady and then slowly increasing in the 2000s up to a high of 3,100 in 2022, whereas California fell from almost 6,000 in 2021 to 2,500 lawsuits in 2022. We have data per month, which, is kind of interesting just to see when we see a lot of lawsuits being filed, because this actually stays somewhat consistent year to year. This year, January, February, March, April, January, February, March, May, June, around 800 lawsuits per month. April, they dipped to 600. And then July through October, we were between 600 and 700. And then November and December, we dipped to about 500 lawsuit filings per month. So you know when the plaintiffs in the courts are at their busiest there. So moving on to website accessibility lawsuit numbers. We have data here from 2017 when we first started tracking website accessibility lawsuits through 2022. And in 2017, there were 814 lawsuits filed regarding the accessibility of websites. And in 2022, there were 3,200 such lawsuits. The most interesting thing about this data is, like I said, 814 website accessibility lawsuits in 2017, 2,200 website accessibility lawsuits in 2018. That was a 177% increase between 2017 and 2018. And then we had a 1% increase in 2019, and then 12%, 14%, and 12% each year after that in 2020, 2021, and 2022. So despite the fact that filings of ADA Title III accessibility lawsuits on all bases decreased in 2022, website accessibility lawsuits remained a huge chunk of that number and actually increased in 2022. The next slide has the number of filings by month. I'll skip over that. It kind of mirrors what I just told you as to all bases, but a little bit different. And then the top states for website accessibility. New York blew everybody out of the water. Why? Because the law is the most friendly to plaintiffs in New York right now. And we have a handful of plaintiffs firms that are filing a heck of a lot of website accessibility lawsuits in New York. Interestingly, we just had a law firm pop up in New Jersey that started filing a good amount. That was fairly new because, as you can read on this slide, we have New York with 2,500 lawsuits in 2022 on website accessibility, followed by Florida in a very, very distant trail at 310 lawsuits. Then Pennsylvania at 216, California at 126, Illinois and Massachusetts in double digits, and Connecticut, North Carolina, Indiana, and Minnesota all in single digits. New Jersey isn't even on the chart. It still would not rate on the chart so far, though, because as of what we've been seeing in 2023, the attorney who's filing the cases in New Jersey is filing them in state court, even though he's usually only alleging a violation of the ADA and not a state law claim. Okay, next we have the website accessibility lawsuits by state year over year. And here it's just interesting to see that New York, we had 355 web accessibility lawsuits in 2017. That increased to 1,500 in 2018, and then up to 2,500 in 2022. Whereas the next three top states, Florida, Pennsylvania, and California, have all stayed pretty steady in their numbers. So enough with numbers. Let's talk about what we're seeing in the courts on some themes. So first of all, the biggest theme of 2022 and years before that, but it seemed like this topic just really dominated the court decisions that we saw in 2022, which is, as I mentioned early on, are web-only businesses covered public accommodations under Title III of the ADA, or does that use of the word place in the statute, is that really dispositive? So the circuit decisions we have, meaning decisions from actual courts of appeal, are in the 9th Circuit and the 11th Circuit. I have noted here Winn-Dixie with stars, and we'll talk about that in a minute. But in those circuits, the courts of appeal say that, and the trial courts must follow it, that web-only businesses are not covered by Title III of the ADA. And as of a couple months ago, California state courts follow the same rule. There must be a nexus with a physical place of business for Title III of the ADA to apply, and for a website that is not accessible to provide the basis for a violation of Title III of the ADA. In Winn-Dixie, the 11th Circuit, in a decision which is now no longer law, said that the barrier on the website must actually prevent access to the goods or services at the physical location, which went even a little bit farther, right? It isn't enough for there just to be a physical business, place of business in addition to the website. The website barrier must have actually prevented access to the business in some way. And courts since Winn-Dixie in the 11th Circuit, despite the fact that Winn-Dixie is no longer good law, have actually followed that same reasoning and said, even though it's not precedential, we do find the reasoning persuasive and we're still following it. In the First Circuit, the business does not have to have a physical location serving customers to be covered, and district courts have applied this precedent to cover web-only businesses. We often hear that the First Circuit holds that web-only businesses are subject to Title III of the ADA, but it doesn't have a decision on point. It's just that the trial courts have been using a decision from the First Circuit to hold that quite often. Other courts, it's all over the map, and we'll talk about that in a couple minutes in a little more detail. Another theme that we've seen, we haven't seen this as much in 2022 because I think people caught on because the courts were so consistent in this ruling, which was if you entered into a settlement agreement with plaintiff A, for example, that you were going to make your website accessible as part of settlement, whether it was confidential or not, but just a settlement agreement between two private parties. And then you get sued again by a different plaintiff B. You can't tell plaintiff B, hey, you can't sue me because I already agreed in this prior settlement agreement to fix the website. That doesn't work. Courts have said it over and over again. If you were under a court order to make the website accessible, that could be a different story, but a prior settlement won't bar a subsequent lawsuit. Being in the process of making your website accessible usually does not moot the case. Other variations of this concept as to what state the website is in and whether that can moot the case, and by moot, I mean the website is accessible. Either the plaintiff is wrong that there are barriers on the website, or we fix them in the meantime. That would mean that, like I told you before, Title III of the ADA only allows for recovery of injunctive relief, as well as attorney's fees and costs. And so if the website is accessible, there's no injunctive relief that a court could order. So that means there's no case or controversy for the court to decide, and the case is moot. If you have a state law claim where there is the availability of damages, like in New York or California, like I said, then the same mootness principle doesn't quite apply, because injunctive relief is not the only relief that is available. Finally, if the plaintiff can't ever use the services of the business whose website is not accessible, then the plaintiff might not have standing to sue, and the case could be dismissed on that basis. And by standing in this context, we mean to be able to bring a lawsuit, you have to have either been injured and or have the likelihood that you're going to suffer future injury. And so these courts have held that if there was no way that you could ever use the services, then there's no injury. We've got some nuances on that will come up as well. The next slide here I have is just a flag for you all, and I'm not going to go into detail. We do get asked very often about tester plaintiffs, about serial plaintiffs firms. I enjoy talking about the merits more than this. And so what we have here is just a flag for you all that we have gotten a lot of decisions on this lately, and some of them are split. So there is a line of cases that says that the plaintiff does not have to have a need to desire, or does not need to desire to patronize the business to have standing to sue. In other words, you know, we would argue, well, they aren't a legitimate plaintiff because they didn't actually want to come buy anything here. They just came here for the purpose of seeing if we were accessible. So there's no injury. Some courts say, doesn't matter. It's okay to be a tester, to be there just for testing it. Other courts say that just encountering a barrier on a website or at a location is not enough. There has to be some sort of downstream consequence to encountering that barrier. So kind of the other end of the spectrum when it comes to just going on to a website, for example, to see if there is a barrier and filing suit. There's a whole lot more cases we could have listed here. Part of the reason why we also say serial plaintiff tester standing here is because some of the outcomes in some of these cases are because the courts get kind of fed up when they're seeing the same plaintiff or the same person filing lawsuit after lawsuit after lawsuit. Okay, next one is Robles versus Domino's, which we're not going to go into detail about because you've all read about it tons. You can read about it on this slide when you get the materials, if you haven't already gotten them yet. And the one reason why it is maintained in this slide deck is because it finally settled in June 2022. So Robles versus Domino's is in fact finally over. And I know Phil is telling me to wrap up, and I'm hoping he's going to let me borrow a couple more minutes due to my technical difficulties. So I'm going to go through here and hit the rest of the highlights for you. Gill versus Winn-Dixie. The takeaway from Gill versus Winn-Dixie this year, I've got the whole history here out for you on the slide because I can't remember it because it went on so long without my notes. But Winn-Dixie also finally concluded in 2022. There was a petition for rehearing en banc. The en banc panel, basically then the 11th Circuit was recalled a mandate that had been issued, began processing a petition for rehearing of the case. And then the 11th Circuit denied a petition for reconsideration of the dismissal of the case. And I guess I should have told you what all that comes from. December 28th, 2021, the 11th Circuit had dismissed the appeal of the case as moot because the website had been made accessible in the meantime. And so we talked about mootness before, no longer a case or controversy because they found the website was now accessible. Okay, let me hit a couple other highlights for you from our key cases and themes. The next couple of slides, which you all can read after the presentation if you would like, are cases that we've talked about before. I still have them in the slides because we still don't have a lot of cases that actually go to the merits. Most are procedural, and these slides talk about actual merits decisions. The couple of other takeaways here for you are the physical nexus slide here. The 11th Circuit, I talked about this earlier. We still have the Hayes versus Dunkin' Donuts case, which, basically talked about the barriers on the website preventing the plaintiff from accessing a physical location similar to the Winn-Dixie holding that's no longer good law that I told you about. And then I just put two exemplar cases here out of district courts in Florida where the courts were following the Winn-Dixie rule, essentially. And I've got a couple of interesting quotes from those cases here as well. In the Lucius case, it is also a relevant one because it's one where we actually did get a substantive ruling at the conclusion of it, where the court found that there actually was a violation of the ADA and ordered the website be made accessible to and usable by visually impaired individuals in relatively short order by January, and the case issued in November, and also maintain and update the accessible so it remains accessible. And you'll see here we also added the cotton wash case that I talked about a minute ago, and some cases in California that have already begun to follow that holding. The couple of other things just to flag for you all, here are some cases on the next slide in Pennsylvania and New York where the courts hold no physical nexus required. And in the Western District of Pennsylvania, they are very emphatic that web-only businesses are subject to Title III of the ADA, just to show you a little bit of contrast there and where the other direction is that cases are going. We've got a couple cases on mootness, the we fixed it cases. The takeaway there is very, very fact specific, and make sure you've got a good declaration from your expert if you want to win on that issue. And finally, standing, we already talked about this. The one takeaway from standing cases is, like I said, for example, if you're suing a credit union that's a regional credit union and you don't live in that region, so therefore you couldn't be a member of the credit union, courts have pretty universally held no standing to sue. But in Young versus Metropolitan Learning Institute from Southern District of New York, again, plaintiff-friendly venue, the court held that informational injury could occur where the plaintiff could not access information on the website as to whether the school could meet his needs, even though the plaintiff said he really didn't have any interest in attending the type of school that it was. So with that, I'm going to let Phil take over. I'll just let you know that when you do get the deck, the last couple of slides are the strategies for avoiding and defending litigation and some tips, which we've been over in prior years, but happy to chat through it with any of you after as well. Thanks for the extra time, Phil.
All right, Kristina, thank you. Thank you. It's just a wealth of information. We really appreciate how much you've worked to put into it. And despite the unpredictable technical aspects, we're really sorry you didn't get to it all. But the slides, as everyone's asking, will be published out on the page for this presentation in a day or two. So yeah, there's over 20 questions. Let me see if we can do 4 to 5, okay? No rush though on your answer. So I'm seeing one that got upvoted quite a bit was relating to customer-facing content.
Okay.
Can you talk about which parts of the law cover digital content that's employee-facing? They're saying it relates to things that go beyond internal, it says. So if there are custom apps or documents that an employee needs to use to do their job, but can't because it's inaccessible, what part of the law could they be looking toward that it violates?
That would be Title I that would apply there. And under Title I, so Title III is unique, and it is really one of the very few, if not the only, anti-discrimination law that requires proactive accessibility. I always use the analogy, you can't wait to build the steps until someone, or build the ramp until someone with a wheelchair comes to your door. You have to, proactively incorporate accessibility principles. Whereas in the employment context, you don't have to put accessibility into play necessarily until you have an employee who actually needs some sort of accommodation. And then you engage in the interactive process to determine what the appropriate accommodation is. So it's Title I or state for employment laws that would apply, which is a different standard.
But it's all, it's the same set of communications technology, right? It would be website, PDFs, the whole internal.
Well, I mean, when you're talking about Title I, you're talking about what does the employee need to do his or her job, the essential functions of his or her job. And if those are things that the person needs to access to do his or her job, then potentially yes.
Great, thank you. Can you address how software as a service companies, especially those that are primarily business to business, might be subject to ADA, if at all?
Oh gosh. That is going to be somewhat fact specific. It is possible that the ADA could apply, but because it's going to be somewhat specific, that's going to take longer than a 3-minute discussion. So happy to discuss that one after.
Great. Okay. You stated that effective communication is the basis for all complaints, or a portion. Can you give a bit more detail on that aspect?
Yeah. So the principle is that, so like I said, to have a violation of Title III of the ADA, you have to have violated one of the 3 main requirements of the ADA, which is you don't have an accessible physical facility, or you haven't maintained it so that it's not accessible. You are not modifying a policy or procedure that needs to be modified to allow somebody with a disability to have equal access to your goods or services, or you are not providing auxiliary aids or services that might be necessary to effectively communicate with someone. So that comes up in contexts like, and the regulations have various examples. And the regulations say that the type of auxiliary that might need to be provided is going to vary necessarily depending on the context and other factors surrounding the specific communication. But the regulations do have a list of things that could be auxiliaries and services that may need to be provided that could be effective. So as one example, it says, an ASL interpreter may be required for a complex medical communication, but if you're in the gift shop of the hospital, passing notes using a pen and paper may be sufficient for effective communication. So because there is no standard in Title III of the ADA that says websites must be coded to X standard to be considered compliant with the ADA, like we have in the physical accessibility area, we have the ADA 2010 standards that state down to the ½ inch or inch sometimes how a building needs to be constructed. Because we don't have anything like that in the regulations or the statute, when people are saying the website is not accessible to me, they're saying, I therefore cannot communicate with you via this electronic information technology to obtain your goods or services business. So you need to make accessible electronic information technology available to me to comply with your effective communication obligation. That's the long-winded way of how it ties into a violation of the ADA.
Awesome. All right. Well, we are at time. We have so many good questions, but that's just a sign of a strong audience and an engaged audience. So again, Kristina was kind enough to offer her contact information, and those of you who would like to follow up with her and with your questions, please feel free. So
Thanks, everybody.
thank you again, Kristina, and thanks to the participants. Have a great AXCon.